A Sydney court has heard how the dividends paid by failed investment bank Babcock and Brown breached the Corporations Act. According to counsel for Babcock and Brown's liquidators, the company regularly made payments to shareholders based on money it had not yet received. Andrew Robertson reports.
Day 2 in the witness box for Babcock and Brown co-founder Phil Green, and another grilling about his role in the multi-billion-dollar collapse of a company that was a bellwether for debt-fuelled expansion. Continuing the questioning was counsel for the liquidators Peter Wood, who focused much of his attention on the relationship between Babcock and Brown and its key operating business, Babcock and Brown International. Mr Green told the court Babcock and Brown's substantive activity effectively was to raise money for Babcock and Brown International. He explained that Babcock and Brown International would pay a dividend each half to Babcock and Brown, which would then be passed on in total to Babcock and Brown shareholders, a policy which had been in place since 2005. Mr Wood focused at some length on the $31 million dividend declared by Babcock and Brown on the 31st of December 2005. It was money Babcock and Brown International didn't pay until February 2006. According to Section 254T of the Corporations Act, which applied at that time, a dividend may only be paid out of the profits of the company. Mr Wood put it to Phil Green that as a chartered accountant and a solicitor, how could you use a payment in 2006 as the basis for the 2005 dividend? Mr Green replied, "I don't practice as a chartered accountant or a lawyer. Babcock and Brown's lawyers looked at this and considered it, and I was told there was not a problem." Can you see there was a problem now? I can't answer that. After dissecting the 2005 dividend, Mr Wood then turned his attention to subsequent years. He outlined a similar pattern of dividends being paid from revenue received after the reporting date. Mr Green repeating that he couldn't see anything wrong with what had occurred. For example, 2007. Peter Wood, didn't you see any problem declaring a dividend for the 31st of December 2007 dependent on revenue received in February 2008? I don't recall any mention of a problem. I don't see a problem. After some questions on Mr Green's personal shareholdings in Babcock and Brown, the hearing was adjourned. The next witness will be the bank's former Chief Financial Officer, Mike Larkin.